This is David Pereira, and I'm going to be presenting to you on how to determine if a mortgage proof of claim is a problem. This is being presented by Phoenix Risen Software. Phoenix Risen Software is a software company that develops software for the legal community. This presentation geared towards a book that is on how to evaluate mortgage proof of claims. This presentation will be just merely to how to identify the problem areas. The agenda in this presentation is going to be pretty simple. First, what we're going to do is we're going to take a look at a common mortgage proof of claim filed by a large institutional lender. There's a slide that we'll go over specific to that. After we review the mortgage proof of claim as it was provided by the creditor, we'll then move towards looking at each section of the slide and identify key deficiencies in the proof of claim that they filed. That should take 3 different slides. After we're done with that, we'll discuss the impact of the flawed proof of claim, and that'll be extremely important. We're going to also have a nice little discussion on what the remedies are for this proof of claim being inaccurate. And finally, we'll discuss the problems equal opportunities. You'll find that Phoenix Risen Software views pretty much everything as a problem creates an opportunity for someone, and in this particular case we'll go into great detail as to how this proof of claim issue manifests itself into a business opportunity for practicing attorneys across the country that deal in bankruptcy cases. So the mortgage proof of claim attachment, which you see in front of you, there was actually 3 pages to the one that was actually filed by the creditor. I'm only including the first page because it makes the points that I want to make with this presentation. I've redacted the name of the creditor and the servicer, and also redacted the case number and who the debtors were in this particular case. But this is very typical, and like I say, this was filed by a large financial institution, one of the top 10 in size in the United States. So this is typical of the kind of proof of claim they're going to file. If you take a look at the mortgage proof of claim attachment, you'll see it's broken into parts. You have part 1, which is really about who the mortgage is and that type of thing, although there is an important section in there about whether it's a fixed accrual or daily simple interest or other. It's interesting on how that's misunderstood. The daily simple interest one is going to be used for HELOCs. The fixed accrual is a little bit confusing because you would think that an ARM would not be fixed, but for purposes of this, I believe they're determining that fixed accrual is a standard type of mortgage. That's the first mortgage on the property. Then you have a part 2 total debt calculation. That tells you what the total amount of the debt is. That's typically also will be reflected on the front of the proof of claim. And then part 3 discusses what the arrearage is. The principal and interest due, and then they talk about escrow deficiencies. And then part 4 is the monthly payment amount. This is what the trustee is going to pay from if you have a trustee in your particular area that makes the post-petition payments as part of the plan. But it gives clear direction as to what the principal interest, the escrow, if there's any PMI, private mortgage insurance, and then the total monthly payment. But a real important section of this form is part 5, and it seems to be the one that lenders have the most difficulty with. And so we'll go into a little bit of detail on that on the next slides. So the loan payment history issues slide really refers to part 5 of the form. There's a lot of confusion over this for lenders. For some particular reason, they don't understand the term accrual, and that may be generated more along the lines because the staff that they have working on these proof of claims may not have the education behind them. It's a bankruptcy department, and you have staff that are generating documents from the computer system and trying to transfer them to this document, not understanding the information that's involved. But whoever developed this form for the bankruptcy court did an excellent job, from someone that looks at accountings all the time, because they talk about whether there were funds actually applied or were they actually incurred. And that becomes extremely important, because in order for you to determine how much the pre-petition arrearage is, you need to know how much the payment is, so whatever the contractual payment amount is, and then its broken down component of principal, interest, and then whether there was an impound account, also the breakdown of that. So a lot of times the contractual payment amount is principal, interest, maybe PMI if there is any, and any escrows. So that's a fairly large payment, and then you have to go across and apply it to the right categories. Although they have a column G which talks about principal and interest and escrow past due balance, that's just a running balance of how much is past due. For some particular reason, lenders seem to be having trouble with columns H, I, J, K, N, M, and O. They just seem to be having a lot of problems with that, because as you'll see, first major box there says contractual payment amount is the monthly assessment of the payment. It is accrued but not paid. So for purposes of the contractual payment amount, it doesn't matter whether it was paid or whether it's accrued. You're going to put that dollar amount. However, how it's going to be reflected on going across the columns is that if it was a payment for some reason that was actually paid, which sometimes you have that when there's a break in payment, it's going to show up in column C as funds received. However, if it wasn't received, it should now show up in the column D as amounts incurred. It hasn't been paid when it's in the incurred. It's due, and then you go across and you have to break down that particular payment. And let's say it's a November 2014 type of payment. And that particular payment there's a balance on that particular date, and then there's an amount that's allocated to principal and an amount that's allocated to interest when you calculate the interest rate on that particular balance. And for purposes of the proof of claim, the balance is updated. So the principal portion of that should reduce the previous month's balance and actually lower the balance so that the next month's calculation is based on the lower principal balance amount. And that's where we see all the problems. And so in the second box there where we talk about the problem, it says in this particular example, here we're pointing the arrows to an actual payment that was incurred, and you see that there's nothing in column H except 0 for the principal portion. You see that there's nothing in the accrued interest portion under I. It's just got 0. And the same thing with the principal balance has not really changed. And you'll notice that as you go down the column with all the other subsequent payments, the principal balance isn't changing. That should be your number one red flag, that if you see payment incurred on this and accrued on this form, if they have nothing, if that balance is not being updated, the proof of claim was completed wrong. And the reason for that is that after you get done with all of the pre-petition arrearage, you're going to be left with a principal balance that's going to be repaid. Even though it's gone down, the principal portion of that balance is going to be repaid as part of the plan. So now when you look to the first post-petition payment, which is currently today being made, you use this new updated balance because you're going to get the pre-petition principal as part of the payment, and you have to work with it. I know the plan in the Eastern District of California specifically has language in the plan that says you are to assume all post-petition payments are to be calculated based on like the loan was all the payments had been made on time. And so that's how accrual accounting types of accounting works, and that's what's going on here. If you see that the principal balance, when you're going down the form, they're assessing payments and they're not updating the principal balance, that's your main problem right there. If you also see that the columns allocating principal and interest are not being completed, those are areas of big problems as well. And then if you see that the escrow balance isn't being updated based on the contractual payments being made in this grid, that also shows that there's a problem. So all of that are the major red flags that you're going to see in that payment history, and that's all going to be impacting the rest of the form. So on the slide that talks about Part 2, Part 3, and Part 4 inaccuracies, the issues that you're going to look at is, well, it says interest due. Well, where did they get that number from? You'll notice that on the previous, where we were talking about they put 0 in on that document, well, there's no place for you to go now and look to see all of that accrued interest, whether it all adds up and equals that dollar amount. And I can tell you that for the most part, that number's inaccurate on most of these proof of claims. In looking at the claim, number one, they didn't give you the information that they were supposed to, that would have added on to that section on the form. But because they're not connecting the dots on putting all the principal and interest and escrows and updating the principal balance on the previous page, this number is inaccurate as well. And then you look at the escrow deficiency, that number is very suspicious as well. So the interest due and the escrow funds on that column, Part 2, is questionable. Then when you look at Part 3, again, now they got even some more different numbers there on the escrow funds. And then finally in Part 4, you see that they have a monthly escrow amount that they're claiming. That's generally going to be problematic, because if you haven't accumulated the escrow properly on the previous page in the history, your starting point for determining what the escrow payments are going to be post-petition are going to be problematic. So when you look at the escrow analysis, which is not part of this review that we're doing, but you'll see that they generally will have negative numbers and things like that. Well, that's not possible. If you have a pre-petition arrearage and there's a shortage in the impound account, that's going to be paid through the pre-petition arrearage. So at best, you're looking at a starting point that should be 0, because you have to assume that's all going to be paid there, and that's where they're going to get repaid. And to start with a negative escrow would be improper. However, as I was pointing out previously, they should be accruing the escrow because they're going to collect it in the pre-petition arrearage. And so you have to run the numbers through and update the balance, assuming the payments were made. And in a lot of cases, you end up with a positive number in the starting point, not even just 0. And so that's really a problem. And so a lot of times they're trying to double collect by claiming there's a shortage in the impound account on their calculation moving forward, post-petition, that's included in the pre-petition arrearage. What we see here is the interest is at issue, the escrow funds are at issue. What we've identified is that there's problems with the proof of claim. And this is all the common problems that you have with these proof of claims. And so we know that. So big deal. What do we do next? 3 ways you can go. Let's talk about the worst case scenario. You can do nothing. And I have to tell you, I see that as a real bad choice. Most debtors are choosing who they get as attorney, not for them to do their worst work, but to do their best. And so they're expecting that if there's something wrong with what the creditor has filed, they're hoping that whoever they've hired is smart enough and will do what is necessary to protect them. So to do nothing doesn't sound like a very good choice. So the other two remedies are really what come into play. One, you can object to the proof of claim, or two, you can file an adversary proceeding. Filing the adversary proceeding is something that's not well understood by a lot of persons. Everybody goes to the objecting to the claim and don't realize that under Federal Rule of Bankruptcy Procedure 3007B, you can object to a proof of claim in an adversary proceeding. So why would you want to do that? The objecting to the proof of claim under 3007A, it's no question, it's the easiest. It's just filing a motion objecting to the claim on the grounds, and is generally used by the least sophisticated counsel. It's fast, depending on the motion procedure in the district you're in. It can be something that gets resolved pretty quickly, but honestly, it's the least profitable. And it's very limited strictly to that. And so so your attorney fees awards are generally a lot smaller. So filing an adversary proceeding has some real hefty advantages. And my impression is it's used by the most seasoned counsel. The process, no question, is slower, but it's also the one that's the most profitable. Attorney fee awards are largest, and damages are available. And the reason damages come into play, because you can generally put in other very closely intertwined causes of action that are a component of the adversary proceeding and the proof of claim. I'm not going to get into a lot of discussion about core versus non-core, but in order for them to make the demands on the escrow, they're using a statute known as RESPA. They have very, very specific requirements in which to meet with that. And so a lot of times, especially where they're claiming that there's a shortage, they are violating RESPA in some particular way. So you may want to have a RESPA cause of action in there. And so generally you want to object to the claim in the adversary. You want to request declaratory relief as to determining the rights of the parties as to all these amounts and things like that. And RESPA becomes an issue. And there's other causes of action which are too detailed to go into at this particular point. But the bottom line is generally the contract, the promissory note, and the deed of trust or mortgage has attorney's fees provisions in them. And at least in California, you've got Civil Code 1717, which makes them reciprocal. And I think that that is the case in other states as well. So you may want to take a look to that. So if all of a sudden they want to engage, there's just more work in doing an adversary proceeding, but that also creates more opportunity for you to collect attorney's fees. Also, you get to engage in discovery without having to, you may be objecting to a proof of claim. You're going to do a 2004 exam of the creditor, which, you'd have to set the motion out long enough for you to get, or, file a request for a 2004 exam, and then the time frame in which you got to serve that, and then getting a response. You're just automatically going to get that in an adversary proceeding. So, of course, you can see from my preferences, that's the way you go. That's what's going to make you the most amount of money. And generally, when you file an adversary proceeding, you might actually get your client a few dollars as well. Like I say, in RESPA, there are some statutory damages for the debtor as well, and you may want to look into those. So with this problem, there's really an opportunity, and honestly, as I've looked at this situation with a lot of clients I consult with, my view is that every law firm that does more than 5 Chapter 13 bankruptcies per month that involve a mortgage proof of claim should have an active litigation staff as part of their business model, because you should be filing at least 3 or 4 adversary proceedings a month on these kinds of matters, because the proof of claims are wrong that often. And then when you tie in the subsequent mortgage payment change notifications, and then the addition of them trying to add fees, so when you take into account the mortgage payment change and the request for fees, those actually supplement the proof of claim. So when you go and look at those code sections on those, you'll see that the terminology they use is supplement. So that supplement creates another opportunity in which to object to the proof of claim. And again, we go back to the adversary proceeding, but you should be taking a look at those as well. Most of the time those are wrong, and again, you'll look at the in-pound analysis or something, and you'll see that they're wrong. That's way beyond the scope of this video, but when my book comes out, you'll be able to see the details of that, but you should be taking a look at that. My review of proof of claims for others is that 80% of them are actionable. So if it's a mortgage proof of claim, I don't care how big the lender is, how small the lender is, 80% of the ones I review, I see some sort of deficiency that allows an objection to be filed in an adversary proceeding to be litigated. And again, I see this as a situation where debtors want counsel who are looking for these problems and who are going to take actions to solve them. Nothing worse than to have a debtor complete his Chapter 13 case 5 years later, and everything closes, everything's fine. 6 months later, tries to go through a refinance, or a year later, go through a refinance, and all of a sudden their balance is higher. There's all these shortages involved, and there's all this money owed, and they don't know what to do. And I can assure you, most of them don't go back to you. They're just thinking they just got screwed in some particular way, and that's not a good way to leave a client. So in closing, a couple things we can help you with if you want. We do a thing called a POCAR report. It's a proof of claim accountability report. It actually has us analyze the specific proof of claim to that case. We won't do the report unless it's reviewed and we determine that there's something to proceed with. The report just becomes the formality of documenting it for an adversary proceeding to show the expert analysis of what's wrong with it. We can also assist you with setting up a proof of claim litigation department if you want, and we can train your staff on this issue. You may already have staff that are kind of doing things like this, but this is beyond them. We can train them, and we can also assist you with common documents such as sample adversary proceedings, and even some sample discovery that are used very specific for these proof of claims. So hopefully you enjoyed this presentation, and if there's anything I can do for you, feel free to give us a call at Phoenix Risen Software, and you can give me a call personally at 916-275-0907, or you can look us up on the web. Thank you very much, and have a good day.